With the start of 2019, it's a good time for California employers to review their hiring practices to ensure compliance with California and local laws. First and foremost, employers need to review their applications. It's a piece of paper that everybody applying for the job is probably going to be filling out. I recommend that everybody does fill out the same application, but employers need to go back and review, especially if they've been using the same application for a few years now. California law has changed in 2018. Employers can't ask about any prior convictions or conviction history, so you need to ensure that the application is up to date and is not asking about prior criminal history or asking about prior salary history as well, or pay history from prior employers. So ensure that the applications are compliant with California law. Next, employers need to ensure that new hires are provided with all of the new policies and are signing off on the policies. Oftentimes, the new hires are given the new policies and they're required to sign the policies, but between having them sign it and getting those signed documents back from the new hires, those documents get lost or maybe never signed. It's important that employers have practices set up so that those policies are signed by the new employees and are actually stored by the employer. Those are key policies to have when it comes to defending any kind of wage claim or employment claim in the future. Now, the next consideration I want to mention is that the hiring managers are trained about these requirements. It's one thing to develop the policies and put them in place, but if you don't train your hiring managers, those policies are worthless. So make sure that the managers understand what California law requires, what they can and can't ask for during an interview, what those applications can and can't be asking for. And the more knowledge your managers have, they can catch issues before they become a major problem during the hiring process. And then last and finally, does the company implement an arbitration agreement and have all new hires sign arbitration agreements? This is a really hot issue. In 2018, the U.S. Supreme Court issued a decision that upholds class action waivers and arbitration agreements. So employers need to take a careful look at those arbitration agreements, work with experienced counsel to draft the right arbitration agreement for their workplace, and understand the pros and cons of having these arbitration agreements in place. So that does it. A few considerations, hiring considerations that employers should review here in 2019. If you have any questions, please reach out to me, and I hope your 2019 is off to a good start. Thanks.